Good morning, everybody. You'll be relieved to know that I'm not going to ask for a show of hands on this one about how everyone is ready and well advanced for GDPR coming into force next May, because we are finding that there's around 6 months to go now until the GDPR comes into force, and many companies are just beginning to sort of realise this and get started. So there is still time, but not a lot of time. And if you're counting the number of shopping days to Christmas, there are 126 working days until GDPR comes live on the 25th of May. So not too long. And the regulator allowed basically a 2-year run-in period. So they've been saying that they're not going to allow much leniency for organisations that are not ready by May 2018. It's been a long road getting to the GDPR. It has been overdue for many, many years. The existing Data Protection Act is horrendously out of date. So in that sense, it's a welcome development. The good news, I suppose, is that if you're complying with the current Data Protection Act, then you're a long way towards complying with the new GDPR, because there's a lot of continuity there going forward. But of course, we see many organisations that are not really complying fully with the existing laws. So it's a good opportunity now, with the new law coming in, to look again at how you're processing people's information, the security arrangements you've got, and make sure that you're coming up to best practice. So I'm going to do, again, quite a quick tour of the main elements of GDPR, and I'm going to try and pull it together towards the end with some practical points. So looking really at what are the main themes. So as I said, a lot of the GDPR should be quite familiar if you have some familiarity with the existing Data Protection Act. The general, what we call the general data protection principles, are pretty much the same, and a lot of the definitions used, although they're a bit clunky, are pretty much the same. So definitions of things like data controllers and data processors, personal data and sensitive personal data, they're all still relevant and still being used, although there are some small changes. So the definition of personal data is still pretty much the same, any information relating to an individual, but it's now been made clear that that includes online identifiers, so that might include IP addresses or cookie identifiers and things like that. The general principles set out on the slide, the 6 data protection principles, again, pretty much reflect the existing data protection principles. And this sort of runs throughout. So as you're looking at your data processing operations, these principles must be very much at the heart of things. Make sure that you're processing data lawfully and fairly, all about transparency, that you're only using it for the limited purposes for which you've collected it and not for other purposes. Minimization, that you're only collecting the data that you need and not extraneous data. Data accuracy, that it's kept accurate and up to date. You're keeping it for no longer than is necessary, storage limitation. And of course, importantly, number 6, data security, that you're making sure that you're following industry standard data security techniques. So those are the general principles, and I think there's another couple of big points just to bear in mind in terms of overall compliance with GDPR. First thing is that you can't process people's information unless you can come within one of the legal bases for processing. And the second one is all around transparency, that people are aware that you're processing their information and what you're going to be doing with it. So just looking briefly at the first one, the legal basis for processing. So again, you can't handle people's information unless you can justify that there's a legal basis for processing it. So it's got to fall within one of a number of different conditions. The main one that people latch onto is consent. And traditionally up to now, consent has been the thing that people have always sort of said, well, if we've got consent, then we can do pretty much what we like. I guess the big change under the GDPR is that, and maybe this has always been the case, but it's much more explicit now, is that consent is much more difficult to get and is perhaps not the ideal ground on which to rely, because people, even though they have consented, can always withdraw their consent, or there may be people who don't consent when you need their consent, and so on. So consent is going to be much more difficult to get. It needs to be an affirmative positive act. You can't have a sort of implied consent. There's got to be a positive act, like a tick box. Pre-ticked boxes will not work. Inactivity won't be regarded as consent. You're going to have to be able to demonstrate and prove that you've got consent, so there needs to be an audit trail, and you have to have mechanisms to allow people to easily withdraw their consent. So going forward, we think there's going to be much less reliance on consent, and that's highlighted particularly in the relationship between employers and employees. Typically, up to now, employment contracts and internal data protection policies have always said that employee data is based on consent. Going forward, that should be stripped away, and reliance should be placed on one of the other grounds. So if we're moving a little bit away from reliance on consent, what are the other legal grounds that we can rely on for processing? Well, just to highlight two or three of probably the most useful ones. First of all, contract. So if you're selling goods online and someone is making a purchase and they're filling in their contact details and so on, then you're processing their information in order to deliver the goods that they've purchased through that contract. So there's a justification there. Compliance with a legal obligation. So we all have obligations to maintain records, for accounting and tax purposes, for example, and lots of other compliance reasons. So therefore you are entitled to retain those records. There may be the possibility of claims in the future and things like that, why you need to retain records for a period. So that's contracts, compliance with a legal obligation. And the third one, which is also is a little bit clunky, but it actually is probably one of the more useful ones that can get you out of issues, is what's called the legitimate interest condition. And that is based on saying that we have an interest in holding people's information. We have a legitimate business interest in having people's information. And on balance, that will do them no harm. In the language of the sort of Eurospeak, their rights and freedoms will not be unduly affected. So having done that sort of balancing act and said we've got an interest to have people's information and they're not at risk, we can process the information for various purposes that we think we have an interest to do. The ones that are particularly highlighted in the GDPR are helpfully marketing. So it's clear that you can hold people's information and use it for genuine, legitimate marketing purposes without the need for specific consent, because it's based on legitimate interest. And other things like data security, prevention of fraud, and transfers of data within groups and so on are legitimate. Now, I've said you can do that, process people's information for marketing without consent, and that's true up to a point, but the big caveat to set aside that is not in the GDPR itself, but in another regulation called the Privacy Electronic Communications Regulations, which annoyingly are also being updated in parallel with GDPR. Unfortunately, we don't yet have a finalised version of those regulations, but they will be coming through probably during the course of next year. These are the regulations that they used to be called the cookie regulations or the anti-spam rules, and they're about requiring a specific opt-in consent for digital marketing. So for email marketing, B2C, you need to have a specific opt-in consent. So you have to bear that in mind specifically when you're looking at direct marketing. So still on the legal basis for processing, where you have one of the special categories of data, what we used to call sensitive personal data, then as well as complying with one of those conditions that we've just talked about, you also need to comply with an additional condition. So this may happen if you're processing some of these more sensitive categories of information, such as information about religious beliefs, sexual orientation, health and physical health and well-being, and so on. More sensitive data. So there are some additional conditions, particularly on consent. It has to be explicit consent. GDPR doesn't tell us what that actually means, but it's a higher level of consent that's required. So that's the legal basis for processing. I said there was a second thing, which is transparency, and again, this is a central pillar of the GDPR, to make sure that people are fully aware of that you have their information and what you're going to be doing with it, who you might be sharing with it, how long you're keeping it, and so on. Because of that, there is a need to review data privacy policies and the like to make sure that they come up to this higher standard set out in the GDPR. It requires a bit more information to be provided than was required under the existing Data Protection Act. So on the one hand, it's saying we've got to provide more information. On the other hand, it's also saying that we have to provide it in a concise, intelligible, transparent, and easily accessible form. So apart from just looking at the words and the content of privacy policies and notices and the like, it's important also to focus on how that information is going to be conveyed, how it's going to be conveyed in an easily accessible format. Maybe lawyers are not the best people to do that. We like writing long documents. But that information needs to be provided in accessible formats. So the regulation suggests possible techniques such as layering, providing information in small bytes with access to more detailed information below, or just-in-time information, providing it relevant information at the time according to where you are, maybe in the course of a website or so on. And use of icons, maybe use of videos, a much more user-friendly way of conveying the information going forward. Another of the sort of big changes that's being brought about by the GDPR is what's called the accountability principle. And this means basically that as well as complying with the regulation, you have to be able to demonstrate compliance. So in reality, it means we're going to have to keep a lot more documentation and records about our processing. We're going to need more audit trail around it. So there's a bit of a bureaucratic aspect to it, but we're going to have more documentation around all of our various data processing operations. And we're going to have to be able to show in each area how it was that we complied, how we got consent, how we have respected someone's withdrawal of consent, for example. There are different aspects of the accountability principle. I'm going to come on and mention a couple in a moment. One of the key ones is privacy by design and privacy by default. So by design means basically we're expected to bake privacy into business processes. So if you're designing a new e-commerce site, then you should think about the security and privacy of people's information right up front as part of the development process, and not as a tack-on or add-on later on. And privacy by default meaning that the default position, for example, for privacy settings should always be by default set to the most privacy protective settings, so that people can then adjust them deliberately at their own choice. So one of the elements of accountability is the need for some organisations, the requirement to appoint a data protection officer. Doesn't apply to everybody. It really depends what you're doing. If you're involved in more high-risk type data processing, so they talk about regular and systematic monitoring of data subjects on a large scale, or processing special categories, sensitive personal data on a large scale. These things are not very well defined in the GDPR, but there is some guidance around it. And many organisations who, although they don't have a legal obligation to appoint a data protection officer, are doing it voluntarily, simply because it's good practice to do so. To have someone in the organisation who has expertise in data protection matters and is the go-to person internally for those sort of issues. So the next area that is also now become a regulatory requirement, but up to now has been voluntary, is to carry out an impact assessment, if you like, a risk assessment. If anything you're doing in data processing has more risk, or again, sensitive personal data, then there's a legal requirement now to carry out a risk assessment. Up to now it's been good practice, but going forward there will be a legal requirement, and again based on documentation, audit trail and so on. Quick look at some other changes. Personal rights is a big theme within the GDPR, giving people control over their own information. So already many of you may have had to deal with the bane of data protection, which is data subject access requests. These are still going to be carried on in the GDPR, although they're a little bit tightened up, so no longer will you be able to charge £10 to get to respond, and no longer do you have the luxury of 40 days, you only have a month going forward. So, but basically it's pretty much the same, although a little bit tighter. The right to object to marketing is also still preserved. But just to look at a couple of the new rights, these are new individual rights that have been introduced by the GDPR and have got quite a lot of attention. One is the right of data portability. So as well as the right to have your information provided to you, maybe in paper form, there's now a new right to have your information that you've provided to a service provider, for example, given back to you in an electronic format that might be usable with another competitive service provider. So if you're on a social media platform, for example, you'll be entitled to have all of your postings and information given back to you in an electronic format so that you could then port it over into another social media service provider. The right to erasure, also known as the right to be forgotten, another tricky one for organisations to be able to deliver. But in certain circumstances, individuals have the right to require that their information be deleted from people's systems. It's not an absolute right. First of all, they have to fall within certain conditions. This doesn't always apply. And second, there are certain exceptions to it. So, for example, if there's likely to be any legal proceedings involved, you can keep the data. But one very much to bear in mind as you're looking at your own systems as to how you would actually be able to deliver on these rights, given that there's a fairly limited time for responding. So controllers and processors, if you're outsourcing any of your data processing to a third party, this might be in the context of marketing mailings or someone providing an online software as a service, payroll processing and things like that, then the GDPR requires that in the run-up to May, we all look at those contracts that you have and make sure that they contain the new GDPR required clauses. There's an existing requirement under the existing laws around this, but the GDPR makes it more extensive. So there is a whole rush on at the moment, people looking at their data processing agreements and also looking again at the liability and how liabilities are allocated as between the controller of the data and their third-party processors. A quick look at international. So the GDPR has some sort of long-arm jurisdiction. So if you have affiliate entities or maybe a parent company outside of Europe, maybe in the US, those international organizations can be directly subject to GDPR if they are targeting consumers in the EU or they're somehow monitoring consumers' perhaps online behavior in the EU. They may be directly subject to the GDPR even though they're not based here. The other big area on international for many organizations, particularly that have overseas affiliates or wider groups or business partners internationally or outsourcing to India or wherever it may be. So where data is being transferred outside of Europe, there is a requirement to come within one of the sort of compliance models. The basic rule is you can't send personal data outside of Europe unless you can come within one of these models. The most commonly used one is what's called standard clauses, which is putting in place a contract between the EU-based business and the international company. So data security, obviously a massive area, particularly at the moment. The news is always full of data security breaches, even today. The key word is there's no data security, there's no data privacy rather, without data security. So it's a fundamental requirement of the GDPR to look at your data security and make sure you've got appropriate technical means in place. I think one of the biggest changes the GDPR has brought about is the requirement to notify the regulator if you suffer a data security breach. So if you get a hacker breach, or maybe it's just maybe it's a ransomware attack, or maybe it's just someone left a laptop on a train or in a taxi, and that laptop had personal details in, maybe HR details or whatever, there is a requirement now to notify the regulator within 72 hours. There are exceptions, but that's the basic requirement. And I think everyone will have seen the news in the past couple of days about Uber suffering a massive data security breach through hackers and not disclosing it to the regulator. So had that been after May, they would have been in breach of that fundamental legal requirement and could easily have been fined many millions of pounds or euros. So talking about fines, I didn't want to dwell on this too much, but maybe just before the break, just to mention that these fines are extremely significant. We think the regulator will flex their muscles on this at some point. Nobody wants to be the example, but we think that they will use these enforcement techniques. But aside from fines, perhaps one of the greater risks is reputational damage. If you suffer any sort of data breach or a problem with your data protection compliance, yes, you may get hammered by the regulator, but you might also suffer a lot of adverse publicity, and that can very much damage your brand and goodwill and reputation. And it can also lead to compensation claims from affected data subjects, as we're seeing with Morrison's, for example, who suffered a data breach some years ago, but there's now a class action being brought to claim compensation. So just to try and pull some of these things together and to give some practical points, what I've got is top 10 tips for you. As I said, we have 126 working days to go. So I pulled out what I think are probably some of the more important actions to be doing. First of all, get your detailed records together. Write a book about all of the data processing that you're doing, what data you've got, what you're using it for, who you're sharing it with, and so on. Data mapping and data inventory, they call it. Re-examine your legal basis for processing. If you're relying on consent, look at some of the other mechanisms. And make sure that all of the data that you've got in the different categories, you have a legal basis for processing against each one individually. Review and update your customer and client data privacy policies. They may be online or maybe in hard copy format, however you're doing your business. Look again at those policies, bring them up to the new higher standard of the GDPR, and look at how you present the information as well. Look at your marketing opt-ins. If you're relying on consent, you have to make sure you can demonstrate that higher level of consent, and also bear in mind the privacy regulations for electronic marketing. Adopt privacy by default and by design. So have that sort of baked into your organisation, that whatever you do, there should always be a champion there asking, well, what about data privacy? Can we comply? Review and update your employee policies. So typically we have information about clients, customers, prospects and so on, but we also have the HR data. So make sure that that is treated as well in the same way. Security, data security. Now's a good time to look at your data security again. Make sure it's up to speed in line with industry standards. Adopt techniques of using encryption or pseudonymization, they call it, where appropriate. And in relation to data security, an important thing to do, I think, is to create an incident response plan. Write the plan now about what you would do in the event that you do suffer a data security breach. You only have 72 hours to decide how to respond, so it's good to get your ducks in a row before that happens, should it happen. Look at your third-party outsourced relationships and review those data processor contracts. Make sure they're up to the new higher standard required by the GDPR. And finally, If you've got some international elements to your business, if you're transferring data outside of the EU, look again at how you're complying with those requirements in that respect. So that was a very quick roundup of the GDPR. I've skated over some of the important areas, but I hope it's helpful. And Steve, I'm not sure whether we take questions now or later. If there are any questions.
On B2B marketing, where you would probably just have an email address and an address, what is the regulation the same, or is it less?
So in the B2B space, so you're not subject to the requirement for a specific opt-in for unsolicited mails. No, not under the Privacy in Electronic Communications regulations. But you are subject to general GDPR requirements. So you'd have to justify having people's contact details for marketing, perhaps relying on the legitimate interests ground I mentioned if you don't have specific consent. It's great to get consent, but often that's difficult to manage, and you might justify having it on legitimate interests basis. Because people always have the opportunity to opt out. If they don't want to hear from you, they can always opt out, and then you must respect that opt-out.
So the MailChimp or whatever system you're using, opt-out would be sufficient in that case?
So if you're sure it's B2B, because with emails, you have to make sure it's a corporate email account and not a personal email account.
So if it's a Gmail or a Hotmail,
right,
or anything like that,
that's a problem. Yeah, that would be classed as. Then you have to have a specific opt-in if it's unsolicited mail. Yeah.
If that email address was advertised on their website, is that still the case that they have to opt in?
So you mean if you've harvested someone's email address?
So a lot of these businesses that we market to are very small. I think they treat it as a consumer rather than a business because they're small businesses. Is that right? They advertise their email address on their website.
Yeah.
So can you legitimately use it then? Or you have to take it?
So if it's not so much to do with the size of the business, it's more to do with, it's a little bit clunky there, sort of legal structure. So if they're if it's a corporate email address, and you're sure it's like a limited company or a PLC, then it's classed as B2B. If it's a personal email address, like a Gmail or whatever, or it might be a business email address, but they might not be a corporate, they might be a sole trader, or they might be a partnership, then that would be classed as B2C. So you'd need specific opt-in. If you're sure it's B2B, then you don't need the specific opt-in, but you still need to be able to justify having their information.
And that's even if it's advertised on there.
Yes, yeah, because someone advertises their email address doesn't give you the right to use it for whatever purpose. And also remember the transparency requirement. As soon as you harvest someone's email address and put it on your system, you've got to tell them immediately that you've got their information and what you're doing with it. So we can't have, going forward, people holding information and the people don't know about it.
So on the new, so whereas before you had to have email opt-in or just cold data, does that now count? So you need it for customer data as well as soon as they buy from you?
So there are, for B2C marketing, for B2C?
B2C.
Yeah, so I mean the position is not that changed from what it is at the moment. So you need a specific opt-in for unsolicited emailing, but if they're an existing customer, then you can email them about similar goods, products. You know, you can continue to do that. This is the regulation I mentioned that is still in process, so we haven't yet got the finalised version of it, but it's following that sort of pathway.